Hope you all had a this holiday season. Alrighty, we're thrilled to have you all here today for a great presentation by Jenny Bratt and Matthew Owens with Sheppard Mullin. They're going to be covering what planners and litigators need to know for 2024. Their materials and our sponsor materials, Douglas Wilson Companies, is at the front desk. Be sure to grab that as you come in. A few announcements just to get started. I certainly wanted to acknowledge a number of folks that helped make this all happen as we come together. David Jacobs of Acumen Insurance Solutions. He is the man as far as the website and meeting registrations and such. Libby Tate of Windward Life Care is helps run our registration and check-in and name tag process. Brandon Robbins of Bernstein and Glenn Arnold of Voight Real Estate. Thank you so much for greeting everybody. Certainly Roberta Robinson and Dan Wilson of Robinson and Wilson need to be acknowledged for spearheading the council's approval as an MCLE estate specialization provider. And Barry Levine of Northern Trust, who's instrumental in getting the council updated with the CFPs for education, not only for this meeting, but also for the 2023 programs. So we're just fine tuning getting that going. February 6th, always the first Tuesday, we've got Doug Wilson and a co-presenter, fresh from the Urban Land Institute fall meeting on the state of the real estate economy in San Diego, Southern California and beyond. Other meetings that we have coming in the future include our annual What the Estate Planners Could Learn from the Estate Administrators and Litigators presentation. We had a great presentation last year with Judge Coletti, and it was, of course, centered on fiduciary problems, and tangible personal property seems to be what keeps the probate court busy. April 2nd, we have a panel led by Pegeen Grayson, Director of Philanthropy at Whittier Trust, with some other of our great plan givers here on how to have conversations with your clients on philanthropy and charitable giving. Without any further ado, I want to introduce Doug Wilson and Michelle Vivas of Douglas Wilson Companies, who's our sponsors. Take it from here, Doug.
Good morning. Good to see everybody. So this morning I am joined by Michelle Vivas, the president of the company, and Michael and Monica, as well as Renee. So we, started to kick off the year with a good showing. Actually, they wanted to start off the year by being nice to me, which is not a bad idea. No, just kidding. Anyway, Happy New Year to everybody. I was driving up here thinking about how for the first thing in the new year, we don't have to be that clever because we're the first thing you're going to see. And also this first thing you're doing, I'm sure the highlight of your week is coming here the morning after the night before, after some people may have gotten slightly overserved the last few weeks. But anyway, it's good to see everybody. Good morning. And thanks to Bill, David, and others for doing such a great job. So I'm going to make this reasonably brief, but I wanted to just share a little bit about Douglas Wilson Companies, for those of you that may not be familiar, and why we're here and why we're so pleased to sponsor. We started, as a little bit of a background, we're known in San Diego for a number of things. One is probably most prominently is a development firm. We built about $1 billion of projects, primarily downtown. Symphony Towers in the 80s, in my youth, when I was 33 to 39, was really the foundation of my experience in San Diego. While doing that, I saw my friends going broke in Colorado due to the energy collapse, and I decided in 1989 to start another business, a business that could do something unique in real estate, actually prosper in bad times, do well in bad times. So I started a counter-cyclical business doing workouts with institutional lenders primarily as a receiver, as a trustee, not in the sense of the trustee in the context that we're working, but in state and federal and bankruptcy court, and have done that now in these 35 years, and about 1,200 projects, about $15 billion all over the country. So we have a unique counter-cyclical background as a firm because we have real life experience, been there, done that, built Symphony and these other buildings by the ballpark, Park Loft and the Mark, but have learned the reality of life, that life cycles impact all of us. We started 6 years ago today, or about today, a new platform within Douglas Wilson Companies that could kind of integrate the two, our knowledge of complex real estate in every shape, form, seeing all the problems, where the bodies are buried, the issues, that dynamic, what went wrong, why things went wrong, and our not just being a predatory developer, but having the credibility of being a fiduciary, of serving, as an agent of the court all over the country on literally that 1,000 projects. And to do that, you have to set the bar pretty high. So we had an idea. We have an aging country. We have an aging America, like the aging world. And there's so much assets that are going to be transferred. Our observation was there are many, many capable people that understand liquid assets, but maybe not as many that really understand the nuance, the trials and tribulation, uniqueness of real estate. And so we started a firm that was going to work collaboratively with all of these professionals, with the wealth managers, with the estate planning lawyers, with the CPAs, where we would come in as an advisor, not as an owner, as an advisor, to work collaboratively with these families and to be able to craft independent solutions that may be, best for them going forward as these assets are being handed out. So Cliff Notes version of what's happened. We'd always done that kind of work, by the way. We never called it the legacy asset management. But as we began to really better understand what our strategy was, we really put it into, next slide. We really decided to segment this into four easily understood steps. The first was to come in, and all of these are different. The first is to come in and to work with the team, to come in to do an objective evaluation of what those assets may be, whatever those assets may be. What are they today? Not what they were 30, 40 years ago, but what are the opportunities today? How have market changes? How has zoning laws changes? How are these things that could affect the better opportunity to monetize those going forward in keeping with the expectations of the family? And so step one was to do this analysis. Step two was then to work with the family to discuss these goals, to work with the other professionals involved in that process, and then eventually to develop a strategy, a plan, a comprehensive plan that was really going to be the playbook that was agreed to by all parties that we then could implement over time, which is the last phase. Next slide. So this is a little bit more detail on phase one, and we did a project recently like this in East San Diego for the Jacobs family, not the Joan and Irwin Jacobs, but the Jacob Engineering family that owned about 65 acres that they bought in the inner city. And there was 65 acres and it was a mixed bag and a potpourri, and they literally needed someone to come in to look at these issues, including the zoning, including, what was the existing encumbrances, what were the leases, what were the financing structures, what debt was coming due. And then we engaged a planning firm that could work with them to redo a plan down that would meet the goals of this property, meeting today's market and capital needs, in doing that collaboratively with all of their other professionals and with the family. Next slide. Once we have, reading sideways is something is an art form I lost a while ago, but I'm doing my best. But anyway, but the next thing to me is really important. And a lot of this, that's working with the family to establish what these goals are. What do the family members want? What are they capable of doing? What are their expectations? Are they realistic? Is there a way to craft a strategy that is compatible with how best to position these assets, but also how to deal with the needs, the nuances, the desires of these individual family members, all of which are not all doing the kumbaya occasionally, which some of you may have observed. And so to do that, I think our background as being a receiver, dealing in difficult, combative situations over these last 35 years has given us the unique temperament to be able to be successful in that environment, to come in to work collaboratively with these professionals in a very even way with our skill set, that no one could deny that we have a unique skill set in that sector. Next slide. Now, once we get everyone's buy-in generally to what we're doing, we want to develop this legacy asset plan. Here's that picture, pardon me. The next slide, please. Thank you. Okay, so now we want to do our legacy asset plan. So this, again, is taking all the information we've compiled, all the holistic objective information, putting that into like a blender, factoring in all of the needs, wants, expectations of the family, factoring in the legal nuance, the tax planning nuance and the like, and we craft that into a plan that we don't just one day say, here it is. Instead, we work step by step in a very collaborative nature to get to that end result. Next slide. So once everyone's bought into that plan, then they have an option. Do they want us to implement the plan or want others to? Or oftentimes, we're not the ones that implement, we recommend other people, realizing that our approach is, we do a lot of things, but our approach is bigger picture, not that we are the best at all of these things, but who might be the best match for an asset in San Francisco that the family has. We had one like that called China Basin for the Lawrence family, Larry Lawrence owned the Del Coronado. Now that was 20 years ago, and we didn't have our legacy platform, but we were doing the same thing, working with their lawyers, Sheppard, Mullin, or pardon me, at that time, Seltzer Kaplan, and a number of others to work with that family on a plan. Now, in that plan, we were the quarterback to oversee the implementation, but clearly we wanted local expertise with hands-on knowledge. So the answer for us is, we're not the best and the brightest. What we want to do is craft a meaningful strategy and a plan and implement the right players to professionally provide oversight to that plan in the implementation. Success is only the result of paying attention and managing the process. All of this other work would be meaningless without that discipline of doing that. So, next slide, please. So this, I wanted to close with this, this slide. This is an interesting, these, by the way, are not the architectural end of the world, by the way, these buildings, we have an architect here that I met. But these buildings are downtown. I put this here because we were approached literally 17 years ago by another lawyer in town who had a client, the Weckerly family, that was in the sheet metal fabrication business. They had a large facility in East County, and they had a facility on this super block downtown, which is a full block and a half, 90,000 feet. We then were engaged to oversee and manage a process of the disposition of this in dealing with the family with their needs from an exchange standpoint and the like. Now, all of these years later, what we see now is what's on that property. But but what the service we really provided, however, was be able to roll up our sleeves, work with that family, understand their challenges, their issues, and the opportunities we could craft to get to a solution that would allow them to take the capital from this particular piece of real estate, looking into the future of what it could be, because 15 years ago, this was not what you were thinking about, and find a buyer to do that. And we worked with brokers and others to achieve that result. So anyway, lots of stories. Next month, I'm going to be back with and share with you trials and tribulations in the real estate of the real estate world. But for this morning, we're just thrilled to be here and glad to be a part of this great organization. Thanks.
Doug, thank you so very much. Really appreciate your help. Doug and Robert Valero, Brian Mulvaney, Glenn Arnold, and others are part of our Planning for Real Estate Family series. So very much appreciate his insights. The January nonprofit spotlight is a most interesting one. Brian Mulvaney is going to come up with Voight Real Estate, and he's one of our advisors in that series. But he's also very active in supporting Father Joe's Villages and their services to the San Diego's homeless. Brian.
Well, we're all very blessed, first of all, to be here, New Year, and great to see a wonderful turnout. The homeless situation in any city, in most cities and throughout America, is a big problem. It's very complex, so you could spend a lot of time, but I don't want to take away too much time from our presenters today because we've got some great information. But obviously, we know it's a problem. Most of us have seen it firsthand. It's spread throughout the county. Bless you. It's a tremendous problem downtown. There's no way to live, on the streets. Some people choose that. So every year, several years ago, I was at an event. I'm on the board at Father Joe's Villages, management board. And so we work, it's a good solution. We have a solution to the homeless problem. It's not 100% effective, but there is a solution. So Father Joe's is a little different than a lot of other organizations. What we do, my brothers and I, it's primarily myself, every year I do a blanket drive and people say, well, you're just helping the problem out. Well, there are people that will not go into a homeless shelter. So we use it as a method of outreach, and I do a blanket drive. And last year I got about 3,000 blankets and raised some cash to buy additional blankets. One year I had a client that donated $25,000 right before COVID. So we could use that for COVID use and relief for the homeless. Father Joe's does absolutely provide homeless shelters, but we also provide a system for getting them off the street, dealing with mental health issues, drug addiction, substance abuse, all the things that make a person become homeless. Nobody doesn't want to start out really wanting to be homeless. They fall into situations, lose their job, and it's a snowballing effect. So we do a blanket drive, and Bill was gracious enough, and all of you, to let me talk about that a little bit. So if you'd like to be involved, and I'll be quick, and then we'll play a little bit of information on Father Joe's. I'd love to have your involvement. It's as simple as getting some friends together, collecting some blankets. You can donate online. Make it very easy. I've sent a blast out, and Bill's rebroadcast it to just, it's a process to at least keep somebody warm and get them through the winter. You'd be amazed when you give a homeless person a blanket, some dry socks, a little toiletries, like a toothbrush, how much they appreciate that. I mean, to see the look on their face and the thanks for something as simple as a blanket, it's very rewarding. But what it does, it also helps get them into the day center so that they can start to communicate. They can pick up their mail. We provide over 2,000 showers a week for the homeless, believe it or not, in one of our centers. We provide meals for them, try to get them in the door, and then give them medical attention. Job training. We've got a culinary institute, security guards, teaching people how to weld, how to code. So there is that's all part of a comprehensive program. And so what I'd like to let you do is hear a little bit from Deacon Jim and what we actually do down at Father Joe's. And I appreciate you letting me talk to you this morning about what our goal and our mission that we're trying to accomplish involves.
Every day at Father Joe's Villages, we see homelessness for what it is. Struggling veterans, laid off workers, displaced families, vulnerable seniors. We see that homelessness doesn't have one face and it doesn't have one solution. For over 70 years, Father Joe's Villages has worked to end homelessness in San Diego. And we continue our commitment to act in ways that respond directly and comprehensively. We use our voice to advocate for effective solutions that bring about real-world change in our communities. Each day, we provide thousands of people shelter, medical care, meals, childcare, and other lifelines crucial to becoming self-sufficient. And to break the cycle of homelessness, we help people transition into affordable long-term housing options so they can build brighter futures. At Father Joe's Villages, we've seen how access to the right resources can help individuals and families in need go from simply surviving to truly thriving. And we're working every day to be the difference. Join us.
So just know that there is a solution. It's going to be hard to accomplish. It'll never be 100% effective, but San Diego is on the cutting edge and probably has a program better than any other in the country and possibly world for trying to solve the problem. And all of you in this room have probably played a small part in helping, and we really appreciate that. And if any of your clients that would like to learn more about Father Joe's, we'd love to give them a tour. We can offer tours and let them know more about what's going on down there. Thank you.
Brian, thank you so very much. You all did I forwarded out Brian's email a day or so ago. So if you want to help track down that email and follow the steps. Certainly I want to bring up Pete Tentler, who I originally omitted from a key person that makes this all happen, but he's our Mr. Networker, and he's going to talk about the trifectas.
Thank you, Bill. Thank you, everybody. Good morning and Happy New Year to everybody. We do a trifecta at the end of the meeting. I'm going to pair you up with two other people, and this is especially for the people that are new to the council or haven't been to the council in a while. Glad you're all here, and yeah, Doug, I'm pleasantly surprised on the turnout right after two back-to-back long weekends. I think some of us gave up drinking, so it's easy to get here this morning. So I'm gonna pass around the bowl. Start at this table. Drop your card in, and again, I'm gonna pair you up with two other people. I'm gonna do my best. A couple of people have said, "Hey, I've been paired up with the same person a couple of times." That's gonna happen. Try not to do it more than twice, just because it's a smaller sample. So start over here. Get together for breakfast, coffee, lunch, happy hour. Those who've stopped drinking, maybe not. So I'll pass this on, bring it around this way, and I'll be in touch with you later this afternoon.
Thanks so much, Pete. For me, the trifectas are just great because the whole key behind it is developing relationships. So it's so much more than what college did you go to, that type of thing, but really what are you working on? And that'll help ring a bell as to a possibility in the future as far as someone that might be able to help you out. So certainly take advantage of that. Now, certainly all the Zoomers, if you can email me this morning, I will connect you with Pete and we'll add you into the mix. You know, certainly it's great education that we're going to have today and in every meeting, but it's the relationships that you've got with the CPAs, attorneys, trust professionals, life insurance folks, and so on. So definitely let us know and we'll add you into the mix. Without any further ado, I want to introduce you to Jenny Bratt and Matthew Owens, newly to Sheppard Mullin. Kind of filling a hole that I've always thought sat out there was, well, where was the big estate planning side? I knew Dick Kins and Jamie and amongst others there over in the M&A side, and Bob Copeland, who passed away a couple years ago, but just the greatest of folks. So welcome to a great firm, and thanks for being here. Both were formerly at Withers Bergman, and I think Sheppard Mullin is fairly international as well, at least as far as offices that I know Jamie's been into. But certainly their whole bio has been included in the meeting announcement. And you can check out their website and get all the details. Jenny's ACTAC fellow, prolific speaker and writer. And frankly, if on the Monday before the February meeting, something happened to Doug, Jenny'd step up and, well, what can I do, and take care of it. And so great, and great to meet Matt today as well. So happy to have you all here. And without any further ado, a question: do you want to sit at your table, or do you want to come up to the? Yeah. Does that work okay? The cameraman has to.
Well, thanks, Bill, and thank you everyone for being here on the first working day of 2024. Matt and I are very excited to present what planners and litigators need to know for 2024. It will be a bit of a year in review, although I don't think we'll be as funny as Anderson Cooper and Andy Cohen on CNN, but we'll do our best. So with that, there's us. All right, so we'll get into the agenda. So we're going to do some federal tax law updates, which I know everyone is very excited to hear. We'll then there's talk about new legislation that was passed in California in 2023, some really huge moves that the California legislature made, some of which I think we know about, but I think a lot haven't received enough attention yet. We'll talk about new cases from 2023 that affect our practices and then impact our clients. And then if we have room for questions, we can have questions at the end. We have a ton to cover, so I don't know, we'll see, but you can also feel free to ask as we're going along. So federal tax law updates. So the big talking point, we'll do one more slide, please, are the inflation adjustments. So the estate and gift tax exclusion amount and the generation skipping transfer tax exemption is up to 13.61 per person. So that means a married couple can do 27.22 million, which is incredible. We also have the gift tax annual exclusion has jumped up to 18,000 per person. So it was at 17,000 last year. As of yesterday, it became 18,000. I think what's top of mind for planners, CPAs, probably everyone in this audience is what is going to happen with the Trump Tax Cuts Act or the Tax Cuts and Jobs Act, and what are we supposed to talk to our clients about? So I think, as everyone knows, but effective January 1, 2026, these amounts are scheduled to be cut in half. And it's all funny numbers because it's adjusted for inflation, but I'm telling clients like anticipate about 7.5 million or so. I mean, we'll see how the numbers actually work. So the amount that you can give away tax-free to your kids and grandkids or non-spousal beneficiaries, non-charitable beneficiaries is going to be cut in half on January 1, 2026. So what does that mean? First, I think it means don't panic. I think I've been doing this for 17 years, and I think a lot of you were practicing or around in 2012. In 2012, we had the $5 million exemption per person, and Obama was in office, and everyone's hair was on fire that those exemptions we're going to lose those exemptions. I remember very well. I was pregnant with my first child, working so hard that I went to preterm labor, but they were able to stop the labor, and he came full term. But it was extremely stressful. And then we saw similar stress in 2020, leading up to the 2012. I think it really started in 2019, leading up to what we thought was going to be a blue wave in 2020 with the presidential legislation. Everyone thought for sure Democrats are going to come in and we're going to see these exemptions go away. So we saw that lot of activity in 2019, 2020. Then we saw the blue wave in 2020. And in 2021, everyone was freaking out and the legislation didn't go through, as we know. So the first thing that I tell anyone who is coming to me sort of with their hair on fire, worried about, do I need to use my exemption, is only give if you think you can give. We've seen, as I just mumbled through, that there have been these inflection points and then the law has stabilized. So no one has a crystal ball. No one knows. The best tax planning always is to give often and give early. So if you can use your exemption, or your clients can use their exemption, go ahead and give it and strategically give it. But don't, I hate seeing people overgive, and I'm sure all of us in the room have seen people who have given away more than they really should have, and then next thing you know, the kids are flying first class, and the parents are on Southwest, right? So we don't want that. I think the other component about these super huge amounts that you can give tax-free is you can only take advantage of these high amounts if you give away more than what the new exemption will become. So some clients will say, I can only give away 5 million, but I got to do it. I got to do it before the law changes. Well, if you're only going to give away 5 million, it doesn't matter if you do it now or when the new law goes into effect, if it does go into effect. In order to take advantage of these big exemptions amounts, you have to give away more than what the new law becomes. So I'm telling people you got to give away at least 8 million if that is the goal. All right, a couple more. I'm going to talk a lot at the beginning, and then I will turn it over to Matt. I promise. And you're going to be like, oh, there's a big pack of slides. You better talk faster. Just a couple of importances, some of which have been brought up at the council. But the first is the estate of Owens versus Commissioner. This was an anticipatory assignment of income case. Now, essentially what that means is if you are trying to make if you're trying to give something away to charity, you have to be extremely careful about the timing so that you don't get whacked with the anticipatory assignment of income. So in this case, the tax court disallowed a charitable contribution deduction for shares in a closely held business, and the shares in this business was gifted just 2 days prior to the closing of the business. So the business was going to be sold, and this guy said, I want to give some of these shares of my business away because I don't want to be hit with the I don't want to be hit with the income tax, and I'm charitably inclined, but I don't really want to give it away until I know that the deal is certain to happen. And unfortunately, the IRS doesn't let you do that. So they're actually the taxpayer kind of got busted in 2 ways here. So first, he gave the shares away when the tax court said, you know what, the sale was certain to occur. There was basically no chance that the sale wasn't going to go through. So we're going to disallow that charitable deduction going in. There were some really, really bad facts. And as we all know, bad facts make bad law. That's how it goes. Yeah. But it was 2 days before the sale. This comes up a lot, and I'm sure I get calls not infrequently of people wanting to do charitable remainder trusts. But again, the timing of when you're going to actually set up this irrevocable transfer is super important. It's always been my practice, and this is a little bit conservative, but not to do, I don't like to do any charitable planning if there's already a term sheet on the table. Now that is too conservative. I will tell you that much right now. You can push it further than that. But in my experience, clients don't always remember all the warnings you gave them. And there really is this whipsaw effect with the anticipatory assignment of income doctrine. So just want to be careful. The other component of this case is that the taxpayer, in addition to waiting just 2 days before before the sale of the company, before giving the shares away, the taxpayer also didn't get a qualified appraisal. As I think we know, if you're giving a significant charitable gift, it actually doesn't have to be that significant. But if you're giving away something other than cash or marketable securities of value, you need to get an appraisal. The taxpayer didn't do that in this case. And so the taxpayer was also penalized for that as well. So practice pointers, get an appraisal, and don't wait too long before doing your charitable planning. A couple other updates. This may or may not have come to a surprise to people in the room, but this was Rev Rule 2003-2, where the IRS confirmed that you cannot get a step up in basis for assets that have been irrevocably transferred to a grantor trust. So there was sort of this like esoteric argument that some people would make, where if you irrevocably transferred assets to a grantor trust, but the taxpayer continued, the transferor continued to be the taxpayer for income tax purposes. So I give shares away to a trust that Matt is the beneficiary of, but it is a grantor trust, meaning I, the grantor, pick up the income. There's some people were saying, well, you know what, you should still get a step up in basis, even though I've irrevocably given the shares away. The IRS had came out with a ruling last year that said, no, you cannot. If you irrevocably give assets away, if the assets are outside of my taxable estate, I can't get that step up in basis when those assets can't get a step up in basis when I pass away. One last case before we go in, I turn it over to Matt, and this is a Sorensen versus a commissioner. So this ended up being a settlement of a Wandry clause case. And so I'm sure some of you are familiar with the idea of a Wandry clause. It's kind of the best of both worlds. I'm going to give assets away to Matt, and I'm going to get an appraisal. But if it turns out that the IRS questions the appraisal, and by questioning the appraisal, the assets that I give away to Matt are worth more than what my appraisal said, there's this formula adjustment. And sometimes the formula says the assets, the overvalue will come back to me. Sometimes it'll say the assets will go to charity. Sometimes there's an adjustment for like a promissory note feature. And the adjustment always relates to if the assets I'm giving away are greater than my exemption. So if I'm giving assets away to Matt and I say, here's a valuation, it's 13.611 or whatever the new number is. And I have the appraisal that backs it up. And then if it turns out on a gift tax audit, the IRS says, actually, they're worth 18 million. Typically, I would owe the gift tax on the difference between my exemption amount, the 13 million, and the 18 million that the IRS says it's worth. These Wandry clauses allow for this sort of automatic formula adjustment. Interesting facts in this case, but essentially the initial valuation had the shares at 5 million. And then a couple years later, the shares were initially at about 10,000 a share. And then they ended up selling the shares for like 20 times that amount. So they got a real good valuation. There was some settlement back and forth with the IRS, but the problem that the taxpayer did in the Sorensen case was when the shares were subject to this formula adjustment, but the taxpayers acted like there was no formula adjustment in the stock ledgers in their dealings with the subsequent buyer. So the IRS argued and was successful in arguing that the taxpayer didn't treat this like actually the shares could adjust, that actually the seller of the company could adjust depending on how the gift tax audit worked out. So I think the practice point from Sorensen is the nice thing is like Wandry is still here. The IRS hates Wandry, but we can still use these Wandry formulas. But to just don't forget to take like the extra steps after you've set up the transaction and make sure that for all third parties, for all unrelated parties, it's clear that there could be a subsequent formula adjustment. Essentially, respect the potential formula adjustment. And I am now going to turn it over to Matt.
All right. Good morning, everyone. I'm Matt Owens. Thanks so much for having me and Jenny here to talk to you guys today. I'm glad that we're giving this talk on January 2nd because, sometimes you go to these updates talks or these, year-end review talks and they get into maybe they're in March or maybe they're in April and the information gets a little stale and it's like, okay, well, that was kind of, a quarter ago, but not us. We're coming in hot on January 2nd. So kudos to Bill or whoever plans, the sequencing of this to have the updates talk actually be right at the beginning of 2024. So glad to be with you this morning. So let's go to the next slide. We're going to get into conservatorship legislation. But before we do that, if you would indulge me just real quick, I want to see how many people actually do conservatorships before I spend time on half a dozen slides on
Or
this.
how many people are subject to a conservatorship right now?
Not yet. I might be on my way, but
I would like to be under one.
could I see a just quick show of hands? How many people actually do conservatorship work? Okay, so I think that's what I suspected. So I'll be kind of brief with these slides. So let's go to the first one. So just real quick, there's a new law on care plans. So if you're in a conservatorship, there's new rules about when you have to file a care plan with the court. I'll just leave it at that because it seems like not that many folks are practicing in this area. Next slide. The Care Court program had an update. So Care Court is not a new law. That's one of Governor Newsom's initiatives that dealt with the homelessness issue and was designed to be an alternative to LPS conservatorships, where people could, by agreement or by court order, come up with a care plan for people that had, psychiatric issues, otherwise issues that result in them not being able to actually function in society without assistance. So we had this care court program that has already gone into effect. That's not a new 2024 bill, but there were updates to it that did go into effect this year, and that's what's on this slide here. So if you deal with a care court issue, you can look back at this slide and see what those updates are. They're procedural in nature, so I won't go into the details of those, but just know there have been some updates to the care court program. And then let's get into trust legislation, which I think will be more, and actually that's going to turn it back over to Jenny, but I promise you'll hear from me.
I swear.
I promise you'll hear from me when we get into some cases
Matt
here.
put these slides together, and it is very much me at the beginning. I promise you'll be done with me. So this is like a huge deal. There's like, so the Uniform Fiduciary and Income Principle Act in California has changed. I mean, this is a big change. It essentially, our old Fiduciary and Income and Principle Act was replaced by the Uniform Fiduciary Income and Principle Act. And this applies when California is the principal place of business or administration of the trust. It is bringing California into conformity with other states. I personally have not studied this to the level that I need to study it, but it is super important for anyone who is serving as a trustee or a fiduciary, because the standards for how you will be investing estate and trust funds have now been modified. Another update is SB 131. This, I think we're all pretty aware of this. So ings, wings, dings, swings, we can no longer do them in California. So you used to be able to create an irrevocable trust in a no state income jurisdiction, transfer the assets to the trust, but remain a beneficiary of the trust. So as an incompleted gift, you would do that to avoid California income tax on gains that occurred within the trust. California shut those down. The effective date was January 1 of 2023. And the impact is, I think there's a lot of people who have these trusts out there now, but they don't really serve a purpose. So the question is, what do you do with these trusts? 99% of the time, these trusts have at a minimum a corporate trustee structure. So there's annual costs and maintenance for keeping the trust in existence. Oftentimes there'll also be an LLC wrapper structure. So there's also this like ongoing maintenance. For clients who have done a liquidation, so there's been sort of a significant liquidation that's occurred outside of California, the client may come to you, or the person may come to you and say, I don't want to be paying $4,500 a year for this corporate trustee anymore. I don't need this. I'm a beneficiary of this trust. When I set this up, I was told I could always take the assets back. So I want to get the assets out of that trust. I don't want to pay that annual fee. The problem is that California has something called a throwback tax. So if the assets are just pulled out of that trust and brought back to the creator of that trust back into California, California is going to pick up the tax that they initially lost. So what do you do in that situation? Option one, the client can leave California. That is like the easiest, except it involves actually leaving California, which has its own difficulties, no doubt. Option two is if the client has enough exemption. So if the client has they haven't used all, or they still have a little bit of their 13.611, I can't remember the number. If they have some estate and gift tax exemption, you can actually convert those trusts into completed gift trusts. So the client would no longer, the grantor, the creator of that trust would no longer be a beneficiary of it, but at least there would still be a good tax purpose for keeping that trust in effect. Once it's a completed gift trust, you can avoid California income tax as long as it's not California sourced income. So that is an option. if there's a state and gift tax exemption left, and if the client is comfortable no longer being a beneficiary. Other than that, I have one client who basically did a cost benefit analysis of the amount of California gain that had occurred within the trust, and is just unwinding it and paying the throwback tax just to kind of be done with that structure and to not have that complication. So depending on a client situation, there's some good options, but for some clients, you may just end up being stuck with it until you die or you move to outside of California. Okay, last piece of California legislation. This is also a huge one. This is SB 801. So California adopted the Uniform Directed Trust Act. So the directed trust structure is a super popular structure, or was a super popular structure that could only occur outside in jurisdictions outside of California until this year. So a directed trust is where you have a sort of a myriad of roles within a trust. Someone could be the investment advisor. Someone could be the distribution advisor. The trustee is just a trustee to gain situs or jurisdiction or to prepare tax returns. Up until this year in California, we weren't able to bifurcate duties between investments, between distributions. We weren't able to say, I'm going to have a trustee that's just going to run the business or that's just going to run the real estate. We weren't able to do that under California law. Now we can. So super exciting. I think this will be a topic you're going to hear a lot more about over the next year, because this is giving estate planners in California an amazing new tool in the tool belt. I'm turning it back over to Matt.
Okay, let's talk about professional fiduciaries for a couple slides. So let's go to the first piece of legislation, which is AB 1262, which is now in effect. This deals with licensing rules for professional fiduciaries. So the first thing it does is if a professional fiduciary has been removed or resigned under protest, there's rules around having to post that information on the internet. You still, under the new rule, have to post that information online, but you no longer have to post, if you're a professional fiduciary, all the circumstances surrounding why you were removed or resigned under protest. So that's a change. And then the other two deal with if you've had a canceled license, or if you've had your license suspended or surrendered or revoked, there's now a process where you can go apply to reinstate it. So that's AB 1262. And then the next one is the Professional Fiduciary Practice Administrator Bill. Okay, so this one is actually the push for this bill actually came out of San Diego. And so what this does is now if a professional fiduciary passes away or otherwise becomes incapacitated while they've got ongoing matters where they're serving as a fiduciary, whether that be a trust, whether that be an estate, whatever the case may be, there's now a system in place that says, okay, well, if there are a bunch of vacancies out there now as a result of that person's death or incapacity, we're going to have a statutory procedure to fill those vacancies. And so what can happen is a specified subset of persons with standing can go to court now and file a petition to say, I want to be substituted into all of those matters on behalf of this now deceased or incapacitated professional fiduciary. And then that person needs to give notice to all the folks that would be entitled to notice for every single trust, every single probate estate, every single conservatorship, whatever the case may be where that fiduciary was serving. And then all of those folks can object or appear and say, well, wait a minute, I want a different fiduciary or whatever. It's supposed to be a temporary system where the person who petitions would fill those vacancies on a temporary basis. And it's actually contemplated that it would only be 45 days. But if no one objects or appears, I think the default's going to be that that person that took over for that deceased or incapacitated fiduciary is just going to have all of those cases then. And so you may have clients come to you and say, hey, I got notice of this fiduciary that's taking over my trust. I want to object. I want to participate in the proceeding and maybe have a different fiduciary or whatever the case may be. So that is pretty big change on how to fill vacancies in that situation. You might have in your trust documents already a mechanism that fills the vacancy. So we're only talking about situations where you don't have a way to fill the vacancy. And so you have to go to court to get someone appointed. So that's what this new bill does. And let's go to some miscellaneous legislation here. So what's the first one up? Corporate Transparency Act.
So Corporate Transparency Act, this is also crazy. I'm sure you've started to hear about it and you will hear a lot more about it. It went into effect yesterday. And it's frankly just a little bit of a nightmare. The goal behind the legislation is to like address money laundering and people who are using entities or trusts to do bad illegal activity. There is now this additional disclosure requirement, both for existing entities as well as new entities. And the penalties for not complying with the Corporate Transparency Act are pretty extreme. We do have time. And we're still waiting on more and more guidance from the government. I mean, all of us have clients with entities, LLCs, corps. I mean, it doesn't matter. And the struggle that I think we're having is who's going to handle these filings. I think most institutions like law firms and banks and even some CPAs are saying we're not gonna take on this filing for you. So it's going to kind of be up to the client to take on the filing. And I think depending on like the sophistication of the client, they may or may not be able to comply. The issue is that when you are completing the paperwork, it's like has to be completed like under penalty of perjury. You have to know who all the owners of the LLC are, or the members of the LLC. And so it's pretty difficult for a third party professional to be able to sort of affirm under penalty of perjury that all this is true, sort of in all instances. I think for certain clients or certain cases, you're like, oh yeah, sure. I just set up that LLC. I know exactly who the owners are. But if you set up an LLC 7 years ago, you don't know if membership interests have been transferred, et cetera. So it's going to create a lot of compliance work, and it's still not clear to me who is going to do that compliance work on behalf of the clients. So there will be a lot more to come on this one as well.
Yeah, I mean, Jenny did a great job giving you the overview of Corporate Transparency Act, but that's a whole presentation. I mean, that's an hour-long presentation easily. There's a lot of content there for that act. Okay, so let's go to the next slide. So AB 288, this is an update on the revocable transfer on death deeds. So we got these a few years back that were passed by the legislature that was supposed to be sort of an access to justice type of estate planning for people that wanted to have a mechanism to do an estate plan around just their house, but not necessarily have to hire a lawyer to help them with that. Boo, right? Boo. And so the people had concerns from the get-go about, okay, well, you're going to have non-lawyers try to do all of these deeds to leave their house. There might be issues. One issue that is trying to get resolved or is resolved by AB 288 is, what if you have a revocable transfer on death deed, but you have a conflicting document out there? So you have a trust that says, well, actually, I leave this house to somebody else, and so it's conflicting with the RTOD or whatever the acronym is that we're using for that. So what this bill does, AB 288, is it says, okay, well, if the other instrument is revocable, so you got a revocable transfer on death deed, and then you have, let's say, a revocable trust that conflicts with your deed, then it's going to be the later in time document that governs. If the other instrument is irrevocable, then that irrevocable document's going to govern. So that's what AB 288 does. It at least answers that ambiguity with RTODs. Next bill.
AB 650, I'm going to move past this. This is, well, it's basically a law that deals with embryos and who controls them. So if that's of interest, take a look-see.
Yeah, and we'll do the same thing, I think, for AB 1029. And let me just tell you real quick what kind of the overview of the slides themselves. So what we tried to do, we knew we weren't going to cover every single slide, and you guys might be looking at how much is left and looking at your watches and getting worried. We knew we weren't going to cover every single slide, but what we wanted to do was for the state court cases that we're about to get into, give you all the state court cases from 2023. So they're all in here except for 2 that came down last week, which irked me because I was trying to get them all in here, but I'll tell you what they are at least. We have all the state court cases, and then we have the state legislative updates that actually impact trusts and estates. They're all in the slide deck. We're just not going to, spend time on every single one of them because we'd be here for another hour probably. So let's go to the next slide.
AB 1268, this is Oregon donor elections via the franchise tax board. So now you can like check a box on that franchise tax board, your tax return to say you're okay being a donor. It's interesting. Matt and I Matt is currently on the executive committee of the Trust and Estate section of the California Lawyers Association. And I used to serve on that committee. And there really is a lot of lobbying in Sacramento to just like encourage organ donations. And so now you can do it on your income tax. SB 890, this is it's a property tax bill, but it primarily just relates to mobile homes or a floating home in a marina, giving some clarity on that if that's of relevance to you or your clients.
Okay, next one is going to be SB 235. So this deals with initial disclosures in litigation matters. So in federal court, you have initial disclosures. As soon as a lawsuit's filed, you have to give the other side certain information and documents. SB 235 requires that you do that now in California state court, except probate code proceedings are carved out. And Jenny just mentioned Texcom, so I have to give Texcom a pat on the back here a little bit because the original version of this bill did not carve out probate proceedings. So the original version of this bill, SB 235, was going to require that even in probate proceedings, every time a new lawsuit was filed, you were going to have to do initial disclosure. So if it's a petition for probate or if a petition for instructions on a limited issue, all of a sudden you're going to have to give all the beneficiaries all certain, information they otherwise wouldn't be entitled to. It's going to be a big mess. So Texcom pushed back on that and wrote a letter and opposed and actually got the bill sponsor to change this bill to carve out probate proceedings. So doesn't apply if you're in probate court, doesn't apply if you're in family court, but some of you that maybe do litigation that find yourselves in civil court, you're now subject to this initial disclosures rule that sort of mirrors the federal court rule. Next one is going to be remote court proceedings, SB 133. All this does is it says the court's ability to do remote proceedings, which we've now been doing for 3 years because of COVID, is extended to 2026, which was welcome news to most folks that were watching that. And then we'll get into trust cases. Okay, so the first one up is Diaz versus Zuniga. And to understand the impact of the real what's going on with this case, you got to understand a couple other cases that are currently up before the California Supreme Court, which is the 2 at the bottom there, Haggerty v. Thornton, which is a San Diego case, and Balistreri versus Balistreri, which is a first district case out of San Francisco. And then we have Diaz versus Zuniga, which is a second district case out of LA. All these cases deal with the same issue. It's about how you can amend a trust. This is pretty relevant for estate planners because this is going to impact, whether a trust can be amended under a statutory method, which I'll explain here. So what happened in Diaz versus Zuniga is the trust document said it could be amended by notice delivered to the trustee by certified mail. And so the settlor of that trust, who happened to be the trust, it was the same trustee and same trustor, same person. Okay, you didn't have like a third party trustee here. That settlor signs a trust amendment, puts it in an envelope, puts a stamp on it, and puts that envelope in their closet, and never sent it to themselves via certified mail. And there was a dispute as to whether that constituted a valid amendment under the trust document. The probate court, Judge Penny in LA said, no, that's not a valid amendment. You had to send that document. You had to send that envelope in the mail to yourself via certified mail and have it delivered back to you, because that's what the trust says. And it went up on appeal and the appellate court affirmed. And that's basically following this balustrade view. There was also an earlier case called King v. Lynch that viewed it the same way. And the analysis is, under those cases, if the trust provides any method of amendment, then that is basically the exclusive method that you have to follow. And you're not able to use the statutory method of amendment, which I'll explain in a second. You have to just use whatever the method of amendment is inside the trust document. And you're just stuck with that, and that's the end of it. There's a different view on the statutory method, which is the Haggerty v. Thornton case, which was Judge Kelledy out of San Diego. And maybe I'm biased, but I think she got it right. But we'll see. It's up before the California Supreme Court now. By the way, 2021 case. We're in 2024. We're still waiting on a decision from the California Supreme Court. That just gives you an idea of how slow these things move when you have to go up on appeal and then all the way to the Supreme Court in this particular case. But this is the most I'll talk, Jenny. So sorry, she's like, I've heard enough about this already. But let me tell you the statutory method, because this is what really the main point is here. So Probate Code Section 15401 deals with how to revoke a trust. 15402 deals with how to amend a trust. 15401 is much more comprehensive. It has more content in it. And in 15401, it says, look, you can revoke your trust by following whatever the trust language says, or it sets up what people refer to, and as I've referred to a couple of times, the statutory method for revocation, which is simply a signed writing delivered to the trustee. Not by certified mail, not by any other method, not, standing up and do the hokey pokey, turn yourself around and then deliver it. Like, none of that. It's just signed writing delivered to the trustee. That's the statutory method to revoke. 15402 says, unless the trust instrument provides otherwise, you can amend by following the revocation procedure. So Judge Kelledy read that 15402 and said, okay, well, unless the trust provides otherwise, I can just amend by using the statutory method, which is a signed writing delivered to the trustee. And the Diaz case and the Balustrade case and an earlier case called King v. Lynch, those cases interpret the phrase, unless the trust instrument provides otherwise. They interpret that to mean if the trust instrument provides any method of amendment, then you have to follow that. And that's why they're kind of analyzing this in a fairly draconian way that you have to follow exactly what the trust says or it's not a valid amendment. Judge Kelledy and the 4th District Court of Appeal said, no, what 15402 is really saying when it says, unless the trust instrument provides otherwise, what it's really trying to say is, does your trust document have a different method of amendment as compared with its own method of revocation? Does it have different provisions for how to amend and how to revoke? And that's what 15402 means when it says, unless the trust instrument provides otherwise. And in the Haggerty case, there was not a different amendment provision as compared with a revocation provision. And so Judge Kelledy said, okay, well, there's not different provisions here. The trust instrument does not provide otherwise. So you get to use the statutory method for revocation, which means signed writing delivered to a trustee. And so that's what happened in Haggerty, which was completely contradicts what happened in Diaz. So now you have the 4th District versus basically the 2nd District and the 1st District. And we'll see who's right when the California Supreme Court rules. Who knows when that'll be? They argued it about a month ago, so people are just waiting on the decision now. But that'll be a big, point that you want to know as a planner is what's the outcome of that case. You could just not even worry about the outcome of that case if you just decide in your estate planning documents when you deal with method of amendment, you just say in there, this is the exclusive method. If that's your client's intent, if they want your method of amendment in the trust document to be the exclusive method, and you say that, then we don't have the Diaz problem, the Haggerty problem in these cases, because in those cases, the trust documents were silent on whether it was exclusive or not. Diaz said you may amend by a signed writing delivered to the trustee, delivered via certified mail. So you could get out of all these cases if you just say in the trust that your method is the exclusive method.
But the cases are scary in because when you they're I think they're scary in a couple ways, and it can cut both ways. But if a client comes to me as a planner and says, I want to amend my trust, it is my practice. Let's go see the method of amendment. But what isn't, I don't think, what I think gets lost a lot is when people are doing an amendment and doing a restatement, which is also pretty common. So someone did a trust from 1986 and they're coming to you and I go, I'm not even going to look at your trust. Like, let's just restate it. We always like to restate it because we want to refer back to the initial trust date for trust funding. But following these cases, that the statutory way of amendment is not being respected in all these jurisdictions other than San Diego. Thank you, Judge Kennedy. I think it's just a good practice pointer for planners, but also anyone in the room who is just seeing these amendments and restatements that happen all the time, and they're not necessarily, the original document isn't on the form that the person who's preparing the amendment or preparing the restatement is familiar with. Interesting.
Okay, next case. Jenny, this one is you. I don't know if you want to, how much we want to do.
Yeah, well, let's move past this. Well, this is actually sort of interesting. Okay, I'm just going to talk real fast. So this is essentially a guy had a power of attorney. The power of attorney said it was silent as to whether or not the agent could open up an account for the creator of the power of attorney. And what the guy who held the power of attorney does, I mean, it sounds pretty shady. He went and he opened up a joint account. And then when the person passed away, the guy inherited the account. And so it's a really tricky way of subverting the estate plan. So this, I think, was a nice outcome that said you can only do that if the power of attorney specifically authorizes the creation of a joint account with the agent under the power of attorney.
Next one, Zandluter versus Mueller. So this deals with if you have a trustee who's defending against a trust contest. So in this case, the trust document, that the third amendment, I believe it was, actually said the trustee was not supposed to defend against a trust contest, and the trustee did it anyway. So that was kind of an easy decision, but it's just a good sort of reminder that if you're going to be representing a trustee in defense of a trust contest, definitely look at the trust document and see if it either directs them to do it. That was the Doolittle versus Exchange Bank case that came out in 2015, I think it was. And in that case, it said, okay, if the trust document directs a trustee to defend against a trust contest, then you definitely are authorized to do it. But it could go the other way too. It could say, I don't want my trustee to defend amendments. And that's what this particular trust said. So the trustee was not able to recover the attorney's fees incurred in defense of that trust contest. Next case is Spears v. Spears, not that Spears, but we might have one for that Spears, maybe next year's update talk, we'll see. This Spears v. Spears, and this doesn't have a proper site because this came down on December 19th, so this is a pretty new case. And so what happened here was you've got someone who filed a petition seeking to be added as a creditor of the dad's trust. And then this guy's filing this from prison, by the way, in pro per. Okay, he files a petition to say, I want to be a creditor of my dad's trust. And then the trustee demurs and says, no, you don't have a proper claim or whatever. The court sustains that demur and says, okay, you got to amend to try to deal with all these defects in your petition. I'm sure it was awful. The guy's a pro per drafting it from prison. I'm sure he didn't do a good job of drafting the thing. Instead of filing an amended petition, he files a creditor's claim. And then the probate court says, okay, well, that's not really the amended pleading that I contemplated. A creditor's claim is on a judicial counsel form. It doesn't look like a petition at all. It's just a different document. And so the probate court said, okay, you didn't do what you were supposed to do. That's not an amended petition. I'm just going to dismiss your case. It goes up on appeal, and the Court of Appeal reverses and says, and this is really, instead not form over substance, but substance over form. The court's like, okay, that's close enough. That was supposed to be an amended petition, so I'll deem your creditor's claim to be, to satisfy your requirement to file an amended petition. Can you imagine the lawyers on the other side of that when they were representing the trustee and they get this pro per, files this thing from prison? I'm sure it was a mess. They win on their demur. They go up on appeal and they're probably like, this person's crazy trying to appeal this based on a creditor's claim. And then they lose the appeal. But in any event, it's just a reminder too that the courts do look at, substance over form, in this case, in the extreme. Next one is Starr v. Ashbrook. Okay, I'm going to skip that one just because it's anti-SLAPP, which is pretty narrow.
We'll skip McGee too. Just
Okay.
the bullet points.
Okay, and I'll skip Joe. But before I do that, before I forget, because we're about to run out of time, I did mention we put every state court case in here in the trust and estates area from 2023, except 2 that came down last week. So let me just tell you real quick what they are. They're not in the slide deck, but I can tell you what they are. So Robinson versus Gutierrez, and I have the site, but I don't know if people are writing it down. Just come talk to me after if you're interested in either of these cases. This is a 3rd district case that came down on December 26th. This deals with the care custodian presumption. So this is in probate code 21380 that deals with, if there's a donative transfer to someone that is a care custodian as defined by the statute, that's presumptively an invalid gift. And so this case was about, well, what is a care custodian and the definition of it? And the holding, just sort of the punchline for this case, is that if you're a care custodian, you're only a care custodian if you receive remuneration. You get paid for what you're doing for the person, the settlor of the trust or whatever it may be. And so in this particular case, the court found that room and board, so moving in with the person and getting basically free rent, room and board does qualify as remuneration and could make you a care custodian. So you might have a case where someone is moving in with an elderly person and just the room and board itself is sufficient remuneration for them to potentially be a care custodian under the statute. That's Robinson versus Gutierrez. And then the other one is Hamilton v. Green. This was from December 28. It's a 2nd district case. This one, I think if there are litigators in the room, this is an important case. This deals with the 120-day deadline to file a trust contest. And so there had been different schools of thought on this hypothetical situation. Okay, trust notification goes out. That sets the 120-day deadline to contest the trust. Let's say that deadline comes and goes. No one filed a trust contest. Could you later, after the 120 days passes, file a civil complaint for elder abuse? Because there's case law out there that says damaging someone's trust, damaging someone's estate plan constitutes elder abuse. There was this whole school of thought out there that, okay, well, maybe you're not really subject to the 120-day deadline if you're filing an elder abuse claim. I never advise clients to follow that school of thought because it seemed too risky and just seemed wrong. But it was kind of like unclear. And a lot of people, there were discussions about this on TexCom and whether there should be a legislative fix, et cetera. This case deals with it. What happened here was 120-day deadline came and went. And then petitioner, complainant, filed a civil complaint for intentional interference with torts, intentional interference with expected inheritance, conversion, and a bunch of other torts, and said, well, I'm not filing a trust contest. I'm filing a civil complaint. Yeah, it deals with the validity of the trust document, but really it's something else. The court said, no, that's basically a trust contest by another name. You're time barred. And so that actually could come up. So be on the lookout for that if you're a litigator and dealing with that 120-day deadline. So those are the 2 cases not in the deck.
Bill, how late do you want us? Should we wrap it up? 9:10. Oh dear, be here. All right. Awesome. Okay, so we are now at, we're past Joe Redland. We have the art museum case. They're not sophisticated enough to pronounce that name, so apologies. But essentially, the decedent created 2 different trusts. Each held a 50% interest in real property. Both trusts named the same trustee, but named different beneficiaries. So the trustee petitioned the court for instructions and, and one beneficiary wanted to sell the property, another beneficiary didn't. The probate court did what I think was the right thing, which is said, just sell the property and distribute it to the beneficiaries. The art museum, which I guess wanted the art, obviously, appealed. But and the holding on appeal was it was vacated and remanded. The holding was where when the trust gives sole discretion to the trustee to make distributions in cash or in kind, it was an error for the probate court to interpret the trust as requiring an immediate sale of property and distribution of the proceeds. But it is scary when you go to court and you do what the court tells you to do and you still get in trouble. Clovis?
Yeah, so next one, this deals with standing in a 17-200 petition. What happened here was the trust owned a 70% interest in a company. And then there was a lawsuit filed by one or more of the beneficiaries, and the company actually filed a response to a 17-200 petition. And the petitioners in the case said, well, wait a minute, you're not a trustee, you're not a beneficiary, so you don't have standing. And the trial court actually agreed and said, yeah, this company doesn't have standing. The appellate court reversed and said an interested person could have standing in a 17-200 petition, even if they're not a trustee or beneficiary. And here you've got a company that had a 70%, or the trust had a 70% interest in this company, definitely an interested person under the statute. So you can't have a really narrow reading on standing for 17-200 because a company could be an interested person.
So next up is law firm of Fox v. Well, it's Fox v. Fox, which is a law firm versus Chase Bank. So a law firm represents the administrator of a probate estate. The law firm was kind of doing everything right. The court confirmed the sale of real property, ordered the proceeds to be distributed into an account at the bank. And then the administrator took all the funds out of the bank account, gave it to beneficiaries, and the law firm didn't get its fees. This is like a sad case for lawyers. But the law firm said, no, not today. We're going to take this up on appeal. Well, initially the trial court said there was no wrongdoing, which I don't really understand. Maybe Matt can explain why, but luckily the good guys, the lawyers won, and they got paid. So small victory.
Okay, Silk v. Bond is the next one, and this deals with the probate exception to federal court jurisdiction. And so what happened here was there was a creditor's claim that was submitted and then rejected, and then the creditor wanted to sue on the creditor's claim, and they sued in federal court. And the defendant took the position that, well, you can't file this in federal court because really this relates to a probate proceeding. And there was an argument, I thought it was a pretty good argument, that in order to figure out what that creditor was owed, you had to know the value of the estate because that creditor was entitled to a percentage of the estate. And so there was an argument by the defendant that, well, this is really getting into like valuing the estate. That's something that's really that's really within the realm of the probate court, which you're supposed to do in state court, not in federal court. So it goes up on appeal, and the appellate court said, no, the probate exception is very narrow, and this creditor's claim didn't fall within the probate exception. So the probate exception is just these three things up here. If you're probating or annulling a will, if you're actually administering the estate, or if you're going to assume actual in rem jurisdiction over assets in that estate, none of which were actually happening in that case. And so the probate exception did not apply there. So we don't see federal court litigation that much in probate, trust and estates disputes, but it can happen. And this is a situation where it did happen. And so you could see that if someone rejects your credit, if there's a rejected creditor's claim, certainly it could be filed in federal court instead of state court if there's otherwise jurisdiction to do that, a reason to do that.
Next case is US v. Paulson. And essentially this is a case that I think confirms what we generally know and hold to be true that that the IRS will always win. But essentially, this was a $200 million estate. There were 10 million in unpaid estate taxes. And the US government went after the trustees as well as the beneficiaries to get their estate tax that was due, and they were ultimately successful. The government was, not a surprise. But it is just a really good practice point when you are administering an estate, advising the trustee, the executor, to really hold back reserves for estate tax and income tax. Because ultimately the trustee can be left, if what I always tell my trustee clients is if you give the assets away to the beneficiaries and then the beneficiaries lose them all, or they're subject to a creditor's claim or whatever, the trustee themselves are personally liable. It's super frustrating for beneficiaries. I'm in a case right now where I actually represent a beneficiary and there's significant reserves and it's driving her insane. But the trustee has to protect itself. Otherwise, they could be held personally liable.
Okay, estate of Kimpton. So this is kind of like I think a funny one. So this attorney, Kenny, represented the administrator of this estate, and then that administrator got removed for not doing a good job. So a new attorney comes in, new administrator comes in, but Kenny had done some work. And so Kenny was entitled to a portion of the statutory fee for this probate, $1,000. But Kenny had also, on behalf of that removed administrator, filed a bunch of frivolous litigation, it sounds like, and had gotten judgments entered not only against the client, the administrator, but also against Kenny. And so one of those judgment creditors apparently surfaced in this probate proceeding and said, wait a minute, this attorney who used to represent the administrator for this estate owes me money. And so instead of paying that $1,000 statutory fee to the attorney, I want you to pay me, the judgment creditor. Of course, the attorney objected, but the trial court said, yeah, I'm gonna approve this administrator's petition, the new administrator's petition, to just pay this judgment creditor instead of paying this attorney, Kenny. Goes up on appeal, and the appellate court affirmed and said, yeah, this was appropriate. The guy owed this money to this judgment creditor. And so the administrator of the estate was authorized to basically divert that $1,000 to pay off the judgment creditor. So Kenny tried to not pay his debt, but he was forced to do so.
Estate of Sanchez. Yep, estate of Sanchez. This is another pro per case. So I'm gonna move past it because I don't think that if you deal with litigation and you have someone who's pro per, I would take a look at that. Bailey versus Bailey. This is another litigation case where essentially someone passed away. They couldn't find a will. They did George Bailey did a petition to open a probate under intestacy. They then discovered a will. They discovered a will, and then there was a big sort of timing argument, and ultimately the holding was that time limits under probate court for filing a petition to probate a will will only bar the will proponent if the proponent received pre-hearing notice of a prior competing petition for probate. This is why I don't do litigation.
Okay, Algo Hares versus Oxnard Manor. So this is a case where decedent died while living in a skilled nursing facility, and then that decedent's successors in interest sued the skilled nursing facility for wrongful death and elder abuse. And the skilled nursing facility sought to enforce an arbitration clause that they had in place with the decedent, who was the patient at the skilled nursing facility. And the successors in interest argued, well, wait a minute, this guy lacked capacity. He couldn't sign this agreement with the skilled nursing facility that had an arbitration clause. And the trial court agreed, and it goes up on appeal, and it was affirmed. The arbitration agreement was not valid because the guy lacked capacity when he signed it.
I'm going to move ahead to what I think will be my last one, which was a case where I learned something. It's on page 52 of the materials, and it's the estate of Franco case. So here again, we had someone who passed away in testate, so no estate plan. And there was a stepson that came forward saying, I'm a natural heir. Or excuse me, sorry, I just got that messed up. There was a child who came forward and said, that was my dad who died. And the court said, no, you're according to your birth certificate, you had a different dad. And the kid said, no, actually, the guy who died was my real dad, even though my birth certificate says he wasn't my real dad. And even though the trial court said, sorry, kid, you're out of luck, that it ultimately got reversed on appeal, saying that there needed to be like proper fact finding. And the fact that the guy who was listed on the son's birth certificate, that wasn't enough without having to do a finding of fact to determine who the actual child's father was. Interesting. And I think we're starting to see a lot more cases like this. And it's gotten me thinking with like my irrevocable trust planning, like, should I, typically we just use definitions of children. And then when you go in the back of the book, what's the definition of children? It's like biological children or children who are deemed to be children pursuant to the probate code. And it's making me start to think, do we want to have a tighter definition of children, given all the things that can happen these days? I don't know. Or that might keep Matt out of business. I'm not sure.
Yeah, I mean, I don't know if you remember, but a few years ago litigated a case over the definition of grandchild, and it was a big case in LA anyway. So I kind of maybe like some ambiguity in there, Jenny. The last one I'll do just real quick is going to be on page 57. It's Gordon versus Irvin Cohen Jessup. I'm just doing this one because let's start off the new year with some good news, which is this law firm not getting sued for malpractice. Well, they got sued, but then they won because the person didn't have standing. This is one of those questions about, can a non-client sue the lawyer for whatever the lawyer did? It's that type of case. So what the lawyer did was prepared an estate plan that did disinherit specified grandchildren from the trust document, but then separately drafted an LLC operating agreement that did not exclude those same grandchildren. And so some of the other family members said, well, wait a minute, clearly the intent was to disinherit these grandchildren completely, not just from the trust, but also from the LLC. And you lawyers screwed up because you let them take something under the LLC because you didn't disinherit them through the LLC operating agreement. The trial court disagreed and said, no, there was no duty to you. You're not a client. And then it goes up on appeal and that's affirmed. The main case on this is that Lucas v. Ham case because it has the factors that you analyze for this type of situation. And after evaluating those factors, the court said, yeah, it wasn't clear, certain, and undisputed that the client, the settlor here, wanted to disinherit the grandchildren from the LLC as well. And so the attorney was off the hook. So attorneys won that one. So, but if you face that issue, hopefully none of us do, but if you face that issue, that's a good case to look at because it goes through that analysis of those factors under the Lucas v. Ham case.
Well, thank you, everyone. Happy New Year.
Thank you.
Hey, thank you all so much for coming today. Appreciate the early birds that get out here. Remember, our next meeting is in February with Doug Wilson on the state of the real estate economy. Thanks for staying. Certainly, I encourage everybody to do the trifectas. And as you go forth in your days with the different folks that you work with, certainly pass on the meeting announcements. We're always looking for the best and the brightest, and thrilled to have you all here and our great speakers. So thanks so much. See you next time.